Okay, this is Judge Paul Bridenstine for Western Michigan University Political Science Class 3250, our Monday, Wednesday, 12:30 to 1:45 class. We're going to do this by YouTube. That is, I'm going to do the lecture by YouTube to my students. We'll pick up where we left off before we had our unfortunate break. I'll announce what it is that we're talking about and go through the notes as if we were in class. The only exception, of course, will be there will not be interaction. You won't get an opportunity to ask questions as I'm going over the material, but I'll highlight that which is important in the book, and then, of course, talk about a few things that are not in the book, as I've done throughout the semester. So what I'm going to ask you to do is take a look at your syllabus. If you've lost your syllabus, let me know, and I'll forward one to you. But we're a little off from the syllabus. I mean, we're behind anyways. When we last met last week, that is on March the 11th, we talked about competency, lie detector, and entrapment, and we were just beginning our discussion about speedy and public trial. So that's Chapter 9, Sections 9.6 and 9.7. I want to talk about that first, and then I'll end this particular video. And the next video will pick up what would be March 11th and pretrial publicity and compulsory process and right to confrontation. These topics that I'm talking about are all in the book, and I want to highlight a few of the things that are in the book for you to know specifically. Picking up where we left off again, I think I mentioned from the beginning that we were talking about speedy and public trial, which was just following our discussion about lie detector tests. Speedy and public trial, particularly speedy trial, begins at page 455. We know this is important for people accused of a crime to have a speedy trial. We know it's important because the Sixth Amendment says specifically that everyone has the right to have a speedy trial. What does this specifically mean? It doesn't mean that the trial has to go quickly. That's sometimes the occasion that an individual might think that, hey, this thing has taken too long, the actual trial. That's not what it means. It just means that the period of time that the person has been charged until the resolution of the case, either because of a plea, a finding of guilty, or a dismissal, happens in a quick fashion. The reason why this is in the Constitution is pretty straightforward. We talked about it in class when we last met. If there is an extended delay, it means an extended loss of freedom, especially meaningful if, in fact, the person is found to be not guilty. Obviously, your reputation is damaged if, in fact, you got to deal with this for an extended period of time. It can be emotionally and financially taxing, waiting for this to resolve. If the government or the court allows this to last a long period of time, it has these kinds of problems for someone who's accused. There's an interest in society to have these cases done quickly. Witnesses forget, they die, they disappear, things like that happen, and so it's important that we put the government in a position where they have to bring the case quickly to resolution. Sometimes the phrase justice delayed is justice denied is thrown about. That's exactly where it comes from. When people talk about justice delayed is justice denied, that's a Sixth Amendment reference, and an individual suffers as a result of the government not putting their case forward. What is critical about this particular provision is that the right to a speedy trial attaches after the prosecutorial phase begins. Just like all of the Sixth Amendment rights that we've been talking about and will continue to talk about, they don't actually take effect until somebody is charged. It does not include the pre-accusatorial or investigative phase. So the question is, why not? Why doesn't the government, under the speedy trial right, have to, from the moment a crime occurred until it's resolved through a criminal prosecution, have to do it in a quick fashion? As I mentioned, and will continue to mention, it doesn't begin until the person's been charged. So what about that period of time in between the crime and the actual charge, that investigative phase? There's a strong interest on the part of the government, and society believes there's a strong interest to give to the government an opportunity to fully investigate the case. If they don't investigate it fully, then what you happen to have is people get charged with limited amount of evidence, and that's not good for anybody. So we want to have the government have an appropriate amount of time in order to investigate the case. What does protect individuals, as I mentioned in class, is what most states have as a statute of limitations. Most states require between the moment in which a crime has occurred until the prosecution begins through a charge. Most crimes have a 6-year statute of limitations. Some crimes, of course, have a little bit longer, depending on the age of the victim. Child sexual assault cases, as I mentioned, might be 10 years in some jurisdictions. Murder cases, those don't have a statute of limitations. That is, if a murder is committed, they could be prosecuted 25, 30, 50 years later, if that's appropriate. But as far as the speedy trial right is concerned, it begins when the person has been charged, and it remains so long as the person is under charge. And so that's what's important to remember. And the factors that we look at in determining whether or not an individual's speedy trial right was denied come from a case I mentioned, Barker versus Wingo, which is at page 458 in your textbook. There are 4 factors, and I mentioned them in class, and I want to go over them again. Again, I'm rehashing a bit about what we talked about in class when we last met, in part because it's important, and also because I went through it relatively quickly. So Barker versus Wingo, broadly speaking, talks about these 4 factors, the first of which is the length of the delay. How long was it between the time in which a person was charged and ultimately the case was resolved? That's an important factor, and a judge, in determining whether or not a speedy trial right was denied, will look at how long the delay was. The second thing to look at are, what are the reasons for the delay? That is, did the government cause the delay? Did the court cause the delay? Or the defendant cause the delay? Let's look at a couple of situations where a defendant may have caused the delay. If the defendant themselves continued to get new lawyers to assist them, and the case had to be adjourned because the lawyers kept coming in to replace an outgoing lawyer, that's a delay that's attributable to the defendant. And that's not something that he can then successfully argue that warrants a speedy trial right violation. That is, if they've caused the delay, it's a problem for them. If they were sick, if while the case was going on, they left the jurisdiction and fled while the case was still being prosecuted, those are things that are attributable to the defendant, and they don't get the benefit of the protection under the speedy trial right if they were the ones who caused the delay. What about the government causing the delay? If the government continued to push off the case because they weren't prepared to go, that's significant for an individual's Sixth Amendment right. So if the government causes the delay, when weighed with the length of the delay, as well as the 2 other things I'll mention in a moment, that will weigh heavily in favor of one being successful on a speedy trial right violation. The third thing is whether or not the defendant, while this was happening, asserted his right to a speedy trial. As we've mentioned with other constitutional provisions, an individual can waive their Fourth Amendment rights. They can waive Fifth Amendment rights. One can waive Sixth Amendment rights, including the speedy trial right. But it appears as though that Barker versus Wingo is telling a reviewing court whether a defendant actually said, I am asserting my speedy trial right. That's one of the factors that is looked at. Doesn't seem like it would have a whole lot of weight, given that they have the right, but it's one that the the appellate court says it should be reviewed to see whether or not there was a violation. The fourth and final factor that is examined, and what has been deemed to be the most important factor, is whether the defendant has been prejudiced by the delay. That is, did their star witness pass away, move, or forget what happened? Were they, in fact, prejudiced because they sat in custody this length of time and couldn't muster up a defense? If evidence was forgotten because of the delay and therefore they're prejudiced by it, those things will work in favor of the defense. So again, it's the length of the delay, the reasons for the delay, whether the defendant asserted their right to a speedy trial, and whether the delay has prejudiced the defendant in some significant way. Those are the things that are looked at. And again, the one that is the most important factor is not the length of the delay, but whether the defendant has been prejudiced by the delay. If, in fact, a court deems that a person's Sixth Amendment right has been violated, the remedy, generally speaking, is a flat-out dismissal of the case. If the government hasn't done what they're supposed to do while the person has been charged and bring it to resolution, the dismissal of the charges against the defendant generally is the remedy. This doesn't happen very often because of a number of things. First, the prosecution certainly knows of this right, does what it can, more often than not, to avoid getting in a position where they might be violating a Sixth Amendment speedy trial right. Another thing is courts are reluctant to dismiss charges based on this because the case is dismissed on something other than its merits. That is, courts like to have cases resolved on the merits of the case, the facts, as they apply to the accused and the incident. When you dismiss a case based on a speedy trial violation, that's something that makes some judges uncomfortable. Not saying that they shouldn't do it, but that's one of the reasons why you don't see a whole lot of Sixth Amendment speedy trial violations. So moving on to public trial in just a second, what I want to do is just to make sure that we're on the same page as it relates to some of the factors. So let me use my handy dandy board. Obviously, it's not as big as the one that we've had in class, but I want to talk about a couple things, and just to show you an example, and then make sure that we understand the idea of a speedy trial right. So, as you can see here, we got the crime occurring at this point in time, the individual charged, and then the trial. Again, when we're talking the speedy trial right, it's this period of time that we're interested in. This period of time does not apply. That's the investigative stage. If the trial comes up to this point in time, say the first trial comes here, and it had to be adjourned as a result of the government not being ready. Well, that would be a good reason why a speedy trial right might have occurred. If this was the original trial date, but the ultimate trial didn't occur to here. If the government caused this delay, then that would work in favor of the defense. If, in fact, the defense caused the delay, that is, if the trial was adjourned between here and this date, and it was because the defense fired his lawyer, for example, and then got another lawyer, then this period of time between here and here would be somewhat attributable to the defense. And so now you're looking at the length of the delay is not really that significant when weighed in favor of the issue of who caused the delay. And then, of course, you look at whether or not the defendant was prejudiced by the delay. If the individual's grandmother, who happens to be the eyewitness, died at this point in time, and then there was another couple of months before it went to trial, then it may very well show that if the trial could have been done during this period of time, that's when it might have been the best to have it done. Because it wasn't done until after the witness died or disappeared or forgot what happened, that would be a consequence to the government because the defendant has shown how he's been prejudiced. So keep in mind these issues as it relates to the speedy trial right. The next topic I want to mention before we take a break, and I'm going to send this off to you, is the public trial. This would be the end of week number 10, March 9th class on the syllabus. So I want to mention the public trial, and then I'll ship off to you this particular YouTube so that you are up to speed, and we'll see how well it works. Again, the Sixth Amendment right to a public trial affords an individual who is accused of a crime to have the public present during their trial. Okay, so it's important to understand the Sixth Amendment right as it relates to the public, because it can be confused with the First Amendment right to have the public present during the trial. So let's talk about them separately. The Sixth Amendment right to a speedy and public trial affords an accused the right to have the public in the courtroom watching what is happening to the accused. The accused deserves to have the public, family members, friends, media, watch what the government is doing to them. This right to have a public trial stems from a distrust of the English tradition of secret trials, commonly referred to as the Star Chamber. Back in the 1600s, 1700s, and in fact in England, past our revolution, England exhibited the Star Chamber as a way in which criminal matters might be resolved. Those were non-public proceedings. We didn't like that procedure. When we passed this particular amendment, we included the right for an individual accused of a crime to have the public present. Some of the basis for this is that witnesses are more likely to tell the truth when they have the eyes of the public on them. Obviously, unknown persons may come forward if they hear about the trial, and that's only going to be the case if, in fact, the trial and notice of the trial is made public. As well, the public is able to evaluate whether justice is being served and have confidence in the system and that the Constitution is working. This is why we have included in the Constitution the right to have the public present that stems from the individual's Sixth Amendment right. The right applies to pretrial procedures as well. That is, when an individual is arraigned, which we'll talk about a little later on in the semester, their hearings to determine whether evidence should be suppressed or admitted, as well as the trial itself. So it applies to pretrial procedures as well. Now, it is often asked whether or not this particular provision, that is the Sixth Amendment right, has to be to a public trial, has to be followed at all times. And the answer to that question is no. There are certain times when a court may deem it to be most appropriate to deny the defendant's right to have the public present. Sometimes this happens when you have gang-related type of crimes, where a judge might find that if the public was present at the trial, it may be intimidating upon a witness, and therefore people may be excluded from the courtroom. When you have a victim of a crime or a witness to a crime who might be tender age, and if the public was present, because the Sixth Amendment guarantees the defendant a right to have the public present, if the public was present, then maybe that witness is not going to be able to testify. So when you have certain circumstances, like a child or tender age witness who might be negatively affected as a result of having the public present, or you have the type of crime that involves a lot of publicity that might, or danger to people, that the court might deem it to be appropriate to close off either all or some of the courtroom to the public, doing so infringes upon an individual's right to have a public trial. So there's select situations when this happens, so it's not an absolute right. The court does have options in which they can restrict the public from being there. Now, let's turn our attention, at least briefly, to the issue of the First Amendment right. And that is, we know in our limited discussion of the First Amendment in this class that media and the public often themselves want to be present during government proceedings. And the First Amendment guarantees the public's access to government activity. So when it comes to the public in a trial, you're really looking at the Sixth Amendment right as well as the First Amendment right. What's important to understand is the distinction between the two, and that is they both involve the public. The Sixth Amendment guarantees the accused the right to have the public present. The First Amendment guarantees the public their right to be present, regardless of whether or not the individual accused of a crime would want to have the public present. So those are two different things on the same issue about the public being present during the course of a trial and pretrial proceedings. Similarly, as a court may take action and limit the public as a result of a witness, a victim, or the type of crime that may have been committed, limit the public's presence, they can infringe on the Sixth Amendment right to an accused as well as the First Amendment right to have the public present. In other words, sometimes a court may take the action to limit television or other sources of media or the number of people who want to watch the case, limit their attendance at the trial. Again, that stems from the First Amendment right. So, again, as I was mentioning, that this right that is vested in the Sixth Amendment to an accused gives their right to have the public, their family members, their friends to watch what the government is doing to them, as well as the First Amendment right to have allow the media to attend these types of things. So that's essentially what I want you to know as it relates to the public trial as well as the speedy trial provisions that begin on page 455 of the textbook. Going through my notes here, I'm just trying to make sure that I've covered those things that I think are important. There's no specific cases as it relates to the public trial that I think are necessary for you to know beyond what's been mentioned in the book. And of course, when it comes to speedy trial, make sure you have a good knowledge of Barker versus Wingo. So what I'm going to do now is I'm going to take a bit of break. We're going to end this particular YouTube, and then I'm going to prepare a video for the next topic, which will be, again, in your syllabus, March 11, 2020, where we'll talk pretrial publicity, compulsory process, and right to confrontation. Those are all related to Sixth Amendment rights again. So as I've been stressing with you, these Sixth Amendment rights don't begin until someone's been charged with a crime. But they're important constitutional provisions, and we'll get an opportunity to talk about that. So I'm going to send this, make it available for you to review, correspond this particular part of the lecture with what you've read in the book, and you should be fine.